Well, hello again, section members and participants. It looks like, for whatever reason, can they hear me? I hope they can. Uh, we've had a YouTube channel problem. The good folks at Cold Box have worked on it, and we're back to Brice now. If you can't hear us or whatever, Annette, our beloved registrar, is blasting out the new YouTube link to everybody. So stay with us. We're sorry about this, and we're back to Brice.
Thank you, Jim. Welcome back, everyone. So I was just discussing before we had a pause the information that we're looking for in the medical records, what kind of information we get from the claimant in regards to those ADL forms, work history forms. So then what? Once we get everything back from the claimant and from the medical records facilities, we try to make a determination. If not, we look forward to we may have to pursue a consultative examination. As I said, one of the roles of a professional relations officer is to recruit and maintain, check licenses on an annual basis for all the physicians in the state that do exams for us. These could be speech and language pathologists, pediatricians, pulmonologists, internal medicine physicians, sort of all encompassing. Couple of the most common ones: internal medicine exams and then psychological exams. Back when I was an examiner, I actually had, this is kind of an interesting example. We were doing a continuing disability review on an individual, CDR, and they thought for sure that they were on disability due to their degenerative disc disease in their lower back, when in fact they were actually on disability due to their bipolar disorder. So that's I've seen that more than once. But that's another reason why we do look at the mental health side, even if it's not an allegation or impairment that's alleged. Sometimes there's some underlying conditions, and we want to make sure we do our due diligence and look at the case as a whole. Just going back to the step 5 or the 5 steps of sequential evaluation, that step 3 about meeting or equaling the listing. I talked about Social Security having the 14 different body systems and all of the impairments within there, which are the automatic allowances. As Kristine mentioned earlier in her presentation, the Social Security website is a great wealth of knowledge. It's an external website. Everyone has access to it. If you were to go to the search function on the SSA website and type in Blue Book, it'll take you to that link, and it'll have the criteria for both adult and children. If they don't meet that particular listing, that's when we move on to the vocational aspect and doing that residual functional capacity assessment, which we talk about on the next slide. So that is when we work with, once we have everything back, we put everything together, work with our team of doctors, our medical consultants, licensed professionals that are contracted by the state of Michigan who help review these cases for DDS. We look at both the physical and mental side. So we look at those residual functional capacity assessments. Once we complete those, that's when we look to see if they have their RFC, if any of their past work is precluded by their current residual functional capacity assessment. The next slide kind of goes into some of the exertional levels that we look at, the classifications. We have sedentary, light, medium, heavy, and very heavy. To be honest with you, heavy and very heavy, we don't see too often because, an individual that may be able to lift 100 pounds frequently, a lot of times their condition would be considered non-severe, if it's not really precluding them from doing any of the work-related activities that maybe they have previously done. Please note, though, that in the sedentary category, we still are expecting that an individual would be able to stand walk for at least 2 hours out of an 8-hour workday. So we do come across individuals with severe back impairments that, maybe they have to alternate between sitting and standing, but they are not able to stand or walk for those 2 hours. So we do have a classification what we consider less than sedentary, or maybe an inability to sustain an 8-hour workday or a 40-hour work week. I know I've seen some of those in some of the ALJ decisions as well. Staying on the slide, though, just because I have the exertional limitations there, there's so much more that goes into the residual functional capacity assessment on the physical end. We have postural limitations, which includes their ability to climb stairs, ladders, ropes, balancing, stooping, kneeling, crouching, crawling. We look at all of those individually, and based on the medical records, we determine, can they never do this? Can they occasionally? Can they frequently? Or are there no limitations? We also have manipulative limitations too. Do they have problems reaching overhead or out in front, handling and fingering? So we look at both fine and gross manipulation. And then those with maybe neuropathy, diabetic neuropathy, we look at the feeling and maybe any sensation loss in their extremities. Just to kind of wrap this up, we also have visual limitations. communication limitations, and environmental limitations. So you may have someone with COPD or emphysema. We would restrict them to environments where they could work in extreme heat or cold or humidity, around fumes, dust, odors, gases, and whatnot. If we have someone with a seizure disorder, we would definitely rule out the possibility for them to work in environments where there's hazards or moving machinery. Next, we look at the mental residual functional capacity assessment. These are broken down into three different skill levels. We have the unskilled level, which requires little or no judgment to do simple duties and activities. They can be learned in a shorter period of time, usually 30 days or less. Next, we have semi-skilled. They can complete simple tasks, and there may be some more complex duties. And then finally, skilled, which is it's high levels of judgment and adaptability. That requires significant understanding and carrying out of instructions, and often in time includes problem solving. So once we have the residual functional capacity assessment, we move on to their ability to perform past relevant work. Again, we're looking at the past 15 years work history. It's usually work that has been performed for more than 30 days, if it's a semi-skilled or skilled position. And then they've had to have worked it to and engaged in SGA. We're looking back, maybe it was 12 years ago, so the SGA threshold 12 years ago is different than it is now. So they didn't necessarily need to make that 1310 gross per month back 12 years ago. You could refer to that prior table. Once we have that RFC, we do the side-by-side comparison and determine if any of their past jobs within the 15 years that are significant and they're relevant, if their RFC allows them to do that particular job. So you may see denial notices from our office that say, although or while you have a severe condition that affects work limitations, we find that you have the ability to do your past job as job X or job Y. So if you see that sort of language in a PDN or personal denial notice, that would kind of hint you to leading to notice that it was denied at step 4 of sequential evaluation. At step 5 on the next slide, we look at other work. So this is when we use age, education, work experience. These are all considered and very important factors. We have specialized advanced examiners who have training, additional training through Social Security and through our training staff on how to use online web-based like description of occupational titles, OccuBrowse, where it gives specifics on particular jobs and what the skills are needed to be able to learn that job. The case specialists use those various tools to determine if they can transfer to other work. Great example, a personal example that I had as an examiner. I had someone under the age of 50, I think he was 48, cardiovascular surgeon. He had some rheumatoid arthritis in his hand, some carpal tunnel. He did have a severe impairment. He was out of work, not able to do his past job. Obviously, he could no longer be a surgeon. But at that step 5, our vocational experts found that, giving the high skill level of that position, that he could transfer to other work within the same field as an advisor or a consultant within the medical community. So in that situation, the high skill level of that position did have a lot of transferable skills. I just want to speak briefly on childhood cases. We're obviously not looking at the ability to work. We're not looking at SGA. They do have to have the medically determinable impairment, either physical or mental, or a combination of the two. It does need to result in marked or severe functional limitations. And again, this is not a short-term disability. It's expected to last 12 consecutive months or result in death. So there are a couple ways you can meet the listing or medically equal the listing. Equal the listing is substituting, maybe they may not meet that specific criteria. For instance, if we have a child with a cognitive deficit or learning disability with a lower IQ that maybe doesn't meet the criteria for intellectual disability, but they also have maybe a compounding speech and language impairment or some ADHD or an ADHD diagnosis that they're dealing with on medications. And so that in that situations, they may not meet the criteria, but they may equal the criteria. Just because they aren't allowance at that level, we do move to the functional equal, which kind of goes more in depth on the next slide. Instead of an RFC, we call this a CDE, a childhood disability evaluation. These are the 6 areas of function that we look at. Internally, we call them domains. So within these 6 domains, we have depending on the condition, whether a pediatrician, psychologist or psychiatrist, speech and language pathologist, they'll look at the medical records and they'll determine the severity within these 6 domains. Kind of a general rule, if you have 2 marked domains out of these 6, that would be a functional allowance, or 1 extreme. So within these 6 domains, there's either no limitation, a less than marked limitation, a marked limitation, or an extreme limitation. So for instance, if we have a speech and language pathologist and a psychologist dealing with maybe a child with a learning disorder and speech and language issue, they're looking at primarily the domains 1 and 3 for acquiring and using information and interacting and relating to others. A lot of the other ones are mostly dedicated to physical impairments. So like our pediatricians would be looking at those as well. So once the child's function is determined, it's compared with the age appropriate activities of that child. So how do they differ from their peers? A lot of the same information we look for information from the acceptable medical sources. The teacher questionnaires, speech and language teachers give us insight. IEPs, the individualized educational plans. For those of you that are familiar with IEPs, they're usually done on an annual basis. So sometimes we are stuck between a rock and a hard place when maybe we had the case in September, but the next IEP isn't until December. Hate to put a case on a hold or anything like that, but we do want to get that most up-to-date information. So that's when we'll reach out to the schools and work with the teachers that are inputting that information into the IEP to get it a little quicker if we can. Medical records, again, from acceptable medical sources, the hospitals, doctors' offices, any psychologists they see, and then it kind of goes with the diagnostic and testing, similar to what we look for in adult cases. So you may be asking how you can help. The big thing for us, kind of the information that we see on that introductory letter that we send everyone, please let us know if there's any new medical impairments, if there's a new medical provider, if there's been any recent hospitalizations, address changes, phone numbers. DDS has taken a goal and an initiative to make sure that we're trying to contact these individuals before we order a consultative examination, just to see if there is any new information. What better source of records than a treating source? So we would prefer to have that information come and avoid the need for a consultative examination, but sometimes that's not always the case. So we do try to make contact with claimants to just get the most recent updates before we order one. So if you have any questions, I do have the list of the professional relations officers within our 4 offices in the state of Michigan. The phone numbers are their office numbers, but we have them all redirected to our Social Security cell phones. So if you have any questions, the emails are valid. You can always reach out and ask us. We're here to help. I'm here to help you. I'm here to help the claimants. I mean, that's the big thing that I do as a professional relations officer. It's all about customer service for me and just making sure that our office makes the correct decision as efficiently and effectively as we can for the individual. Whether it's an allowance or denial, these individuals need to know in a timely manner because we do realize these people are out of work. And so again, I thank you all for allowing me to come in and talk about our program, and I'm sure we'll have some questions. Kristine?
Thank you, Brice. I appreciate that. That was a good overview of the disability process. So now I want to go back into a little bit about the appeals and the changes that have been made during this pandemic. One thing I do want to mention is a lot of us are still at home. So in our offices, whether it be the field or the hearing office, there's usually only a few people in the office on a daily basis dealing with mail or printing or anything like that. So there's a lot less people in the office. They have sent all of us home. We are working from home and trying to do what we can for our claimants, for you guys. A lot of our stuff is done by mail, by fax, by phone. Everything we're currently doing, all of our appointments we're taking are over the phone. So that's why I keep referring back to the online stuff, because it's the fastest, most efficient way to get the information to us for you or for the claimant. So we have advanced so much in our online services. We recommend that everybody do as much as they can online. Now, we know that there are cases that you will not be able to appeal online. You will not be able to file online. We understand. And we ask that you pick one avenue to get that appeal to us. So whether that's by fax, by mail, one of them, please, because we tend to get lots of duplicates, which is fine, because things can get assigned to certain people and maybe don't hit the file fast enough, but we tend to get lots of duplicates. And so we're asking everybody to pick one avenue to contact us when it comes to filing an appeal, whether it's online, by mail, or via fax. So one thing I do want to talk about is we have expanded our online appeals. We can request the reconsiderations online, the hearings online, a review by the appeals council can all be done online. At the recon and the hearing level, you can appeal the non-medical decisions as well. Those can come through on the online services. So I recommend checking it out. You can start an appeal and then go back to it later. Claimants also have access to see what the status is of their appeal on their online My Social Security account as well. So another avenue to explore with your clients if they have questions and maybe they don't need to necessarily call you all the time. They can get on their online account and see what the status is of their, initial claim, reconsideration, or hearing. They can see that kind of stuff. So the next thing that I actually talked to the hearing office recently. I used to work there, and so I have a good rapport with them. And I was asking them about what's going on with them doing all these phone and video hearings and what the difference is and how it's going. And they said that cases are coming in and they're scheduling them fairly quickly. A lot of cases are being scheduled before they're even exhibited. So as you all know, a case doesn't get exhibited until it gets to the hearing level and they schedule it or they have a hearing so the judge can use the exhibits and that kind of stuff. It used to be when we had a little bit of a backlog at the hearing office that they would work up the cases, exhibit everything, update anything, send you letters, like this, we've updated the file, please take a look. And then they would schedule it for a hearing. Well, that's not the case anymore. They are scheduling them a lot of times before they're even exhibited. So it's not a most up-to-date file at that point. It's just being scheduled for a hearing. And then, the short time in between it getting scheduled and actually having the hearing, that's when the most work has to be done to get that file ready so that we have everything for the claimant, that, medical records, anything we're missing, they scramble to get that in there. So they started sending these COVID-19 public health emergency hearing agreement forms out. They come out with the request for hearing acknowledgement letters. They are going out pretty quickly with, asking if you want a phone hearing or not, or a video hearing or not. And I'm going to talk about the video hearings at the hearing level shortly, a little bit more in depth. But the sooner that they can get these forms back from you all or from the claimant, the easier it is for them to either postpone it if they have to, or get it on the books and schedule it. So this is a form that's available for all claimants. And this is actually available on our website as well, that you guys can have readily available. So you're not actually waiting for that request for hearing acknowledgement letter to come out before you can fill it out and send it in for your clients. So next I wanted to talk a little bit about the video hearings that are coming at the hearing office. They haven't rolled this out yet, but I know in our other components, so in the field and I believe at the Disability Determination Services Office at DDS, they are doing some video hearings for different things. So at the field office level, we are currently doing video, not hearings, but video appointments for our claimants who need a replacement Social Security card. And there are certain criteria that they have to meet to be able to do that video. So the agency is expanding this across the board for different scenarios and that kind of stuff. So, and I believe at the Disability Determination Services Office, our disability hearing officers are holding hearings by video in a lot of ways too, to be able to complete their cases and that kind of stuff. So there's a lot of information available on our website again. The hearing office has not rolled this process out just yet in Grand Rapids that I know of, but I know they are pushing for it, and hopefully in the next 2 months or so, they were hoping to have this out to be able to do video hearings with claimants and with the attorneys. So during the pandemic, as I'm sure you all are aware, the average processing time for our hearings have drastically gone down, which is a good thing. They are working very hard to get these in and out and have this average processing time down. Now, this was a graph that I pulled off of our website. It shows a significant difference from, 2017, if you look at that, where we were 600 days for average processing time for a claimant's hearing, to now we're 300 and some. I think Grand Rapids is actually 279 is what I looked at yesterday. So it's significantly down. And, you know, we used to wait years for claimants to have their hearings, as you all know, and now they're pushing cases in and out fast. And so a lot of that comes with the agency initiatives. I know part of it has to do with the recon being reinstated in the state of Michigan, and getting a little less hearings coming in the door. But you know, it's still, with all the initiatives that they push for electronic and more electronic cases, it makes it easier on the hearing office to move those cases in and out. All right. Well, I just want to take the opportunity to thank you guys for having us. We are thankful to be here to give you some updated information to answer these questions. As Brice said, our email addresses are on here. So if you do have questions, you know, you can reach out to us. But a lot of claimants can get a lot of this information online as well as you. So every day we're updating the online services that we provide for the agency. So with that, I'm going to turn it over to Josh.
Hi, folks. All right, so we've got some questions for our presenters, but just ahead of time, I just want to note that while we had some problems with the stream earlier, we have recorded everything. The recording is good, and that will be uploaded to the website shortly, so you guys will have a link. And so in case you missed anything, you'll be able to get it that way. So a couple questions, and I guess this can be either one of you if one of you can chime in. The first question that we had is there an equivalent to a hearing status report for the reconsideration cases, or do you know if some type of equivalent is going to be made? I know personally, when having that access for the OHO level, seeing all my cases in a row, their statuses and things like that is helpful, not only just to know where they're at, but also to know that they've got it in the system and that I'm listed as rep. Do you know if there's anything going on like that for the recon stage?
As far as I'm aware, I have not heard of anything. I believe you're talking about the DART reports that the hearing office would release that shows all the updated information, statuses, and that kind of stuff. I have not heard anything. If they're going to release something like that, I will pass it to Brice and see if he knows more.
No, that's same answer. I'm not sure. I haven't heard of that.
Sure. All right. Another question that we had is the best way to submit the 1696, either at the initial or the recon level, to ensure that you guys get it. Fax, mail, both, certified mail. How would you recommend doing that?
So I would recommend mailing it. We do have, as I stated before, we have about 4 to 5 people in the office on a daily basis, and their primary job is to bring in the mail, open it up, scan it into the system, get it over to the appropriate individual, mail out any documents that need to be mailed. My recommendation is to get it to us by mail, so that way we can make sure it gets scanned right into the system. Now, this is a kind of a twofold thing. When we scan stuff into the system, you're still not added on as rep until we do an input in our system. So we could have your 1696 in our records, and I'm sorry about this, for a while, but we haven't added you on the case, which doesn't give you the electronic access to the claim and that kind of stuff. So we are working on a more efficient way of giving you guys that kind of access the minute they come in the door. So I say my recommendation is going to be mail it to us, because then we know it's automatically in the system. With the faxing, if they get routed to an individual that's assigned to your client's case, and it might not hit the client's file right away. So if you call the main line and you're like, I'm the attorney, and then they're like, well, I don't see it. So we don't want to do that. My recommendation is going to be to mail it.
Okay. I'd like to touch on that too, though, if I could. So a lot of times we'll get contacted by attorney reps about needing to input a new 1696. We do have to direct those all to the Social Security field office. We were contacted just recently by one that had, I think, dozens of people they were representing, and wanted us to do a query, and we just weren't able to. Our system doesn't allow us to run third-party queries for attorney reps, and so it's important that that information goes to the Social Security office, so then they can update it. Because if it were to come to us and we update it on our end, Social Security is not going to see it. It needs to come the other way.
Okay. And then I think, Kristine, you mentioned that there is some access for the claimants through the My Social Security account that they have to their file.
Yep.
how long is that active for them? Is that always active? Can they always download things from there, or is that closed like it would for a representative after some point?
You know what? I'm not 100% sure on this one. This is something that they just fairly released to us and to the claimants themselves. So I looked at it the other day, and I can't remember if it said it was only for a certain amount of time. I know the documents go into the claimant's inbox in their My Social Security account. So I believe that they might have access to it for a while, but I honestly can't answer that if it turns it off after so long. But it is something like they will have to call the local field office and say, hey, I want my file sent to my Social Security account, and we have a system in place. Similar, it's honestly similar to how we burn a CD. We just click a few boxes and send the stuff directly to the client, and they can see it within minutes and upload, pull the documents in and that kind of stuff. So it is fairly fast. I just don't know if it goes away.
Okay. Another question, actually, I think it was more of a comment from somebody indicating that the HITMA requests, particularly from the VA, are you guys aware that it only contains the 10 most recent chart note entries, some of which can be phone calls and things like that, as opposed to the complete chart?
Yes, we're aware of that. There were some snafus and some issues with VA VA HITMER, but we've kind of instructed our examiners to do that. There's so many attempts and so many requests we can do. We can expand date ranges, and then also we can. I mean, the advantage of HIT is we can get it instantaneously. I can get it within a matter of minutes. But one thing that we've seen with HITMER, sometimes it doesn't include path reports, visual acuity testing, the pulmonary function test tracings. So in those situations, our examiners are writing directly to the VA source, sending a traditional request to get those missing pieces. We do work with VA to try to get them either on Electronic Records Express or outbound fax, just to make sure we expedite those requests.
Okay. And will we see SSI apps be available to be filed online?
Yes. So they have actually expanded this in the last year where they've included more claimants to be able to file SSI applications online. Now, there are certain exclusions, and I can't give you all the details of why a case gets excluded, but they are working towards advancing that to ensure that more claimants can file their SSI applications online. My hope is that someday they will get the SSI child's cases to be able to be filed online. But with that, it comes a lot more information that we need. So we need like the household information, so, parents, other children, that kind of stuff. And I think that's why the agency hasn't pushed to that just yet. But they are working towards it. I know in the last year, they've opened it up a little bit more for more claimants to be able to do an ISSI claim, is what we call them. And so we're hoping that in the future, they push more of those out so that we're not getting so many exclusions where the claimant's going to have to call and schedule an appointment to talk to one of our claim specialists, or we send the case to DDS without the SSI claim, and then down the road the claimant calls us and says they want to file an SSI claim. So we're hopeful that in the future soon that we have that capability for more people to be able to file the SSI claims online.
And do any of you have any knowledge about OHO hearings going to a national scheduling system? And if so, does this mean no more local hearing offices for video or phone hearings?
I have not heard that at this time. So I know they do a centralized scheduling unit now, where it used to be each office scheduled their own hearings, and then now they have certain people in the region that schedule for multiple judges in multiple offices. But I have not heard about the national scheduling or national hearing stuff. That is out of my purview.
Anything from you, Brice?
Nope, that's definitely out of my purview as well.
Okay. All right. This one's a question for Brice. What access does DDS have to prior claims, medical decision, etc.?
I mean, everything that's in the eView, we have access to. I mean, it can go back. I mean, we've been using eView since I started in 09, and even prior to that. So we're able to see all the prior decisions, all the prior 831s, the decisional information from Social Security, all the prior ALJ decisions, all the prior records. We obviously review those when we're looking at continuing disability reviews. So yeah, all that information is available if the case was electronic. We handle some cases that are paper, for like our office retirement systems and our state inclusion workload. But for the most part, all the Social Security cases we are able to access through eView.
Okay. And a question for Kristine. Will we get access to the A file at the recon level soon?
We are very hopeful to be able to give you access to more sections of the file. I know the E and F are helpful to you guys, but I know you guys want access to the A file because that includes the ALJ decisions. A lot of our prior ALJ decisions are in section A and the prior ones that you guys look at. I know those are food that you guys like to have. So hopefully they will expand that access soon. I'm very thankful that they have at least released the access to you at the initial and recon level. So we're hopeful to get more access for other sections of the claimant's file at those lower levels as well.
Okay. And I guess as a follow-up to that, do you know if the claimant has access to the disability determination explanation outlining the RFC and all those things from the initial determination through their own My Social Security account? Or is that the same answer?
No, so the claimants can, like it's the same thing as us burning a CD. The claimant can have their entire file burnt on a CD and mailed to them. It's the same thing with the electronic access that we now offer with the My Social Security account. They can request their entire file be sent to their My Social Security account, or they can ask for, you know, their DE or ALJ decision or a consultative exam. They have that capability to ask for those questions or those documents. I'm sorry.
Okay. And one of the questions here, the online application currently only provides two options. I'm applying by myself, I'm applying for someone else, and they're not with me. And there's no option for when the claimant is with the individual assisting with the application. Are there any plans on fixing that? There's basically, it's almost like you're lying if the person's right next to you and you have to answer that you're the one helping them.
I'm not sure that they're going to change that anytime soon, because the thing that we always look at, we always have a claimant attest to the application. We want to make sure that the individual applying for the benefits is actually our client or our claimant. And so I'm not sure that they will ever change that, because we want to make sure that the claimant understands that they're filing the application. So if somebody is helping them, we always send it to them and have them sign it and say, yep, I agree and I want to do this. But the risk that we run is we would have somebody else apply for them and they may never see the application, and we don't want to take that away from them, because we still do the verbal attestation or the wet signature to make sure that they know that they are filing for these benefits and this is what they stated. You know, so I don't see that going away anytime soon, just because we want to make sure that claimants are aware of what they're filing for.
Okay. Yeah, let's see. Oh, why can the OHOs not request HITMER for us unless we have already been denied in our own request?
I am honestly not 100% sure on that one. I know that at the hearing level, the burden on the reps or the claimants to provide that information to us. So as a representative, they ask that you guys attempt to request the information, and then if you are unable to get that information, then you contact us. That's just the way that it has always been. I honestly don't know the answer to that. I've been out of OHO for long enough that I'm not sure.
Sure. All right. Next question has to do with some fees and possible overpayment issue. If you have an agreement for fees not to exceed $6,000 and you receive two checks because of children, which combined exceeds $6,000, are you allowed to give the excess to the claimant, or do you send it back to Social Security so they can return it to the claimant? I believe I know the answer, but we'll get the authority on it.
Our recommendation is always to give it back to the agency so that we can account for who gets paid what, and we make sure that we're not overpaying a representative and that any monies that shouldn't have gone to them goes to the claimant. So we have a tracking system in place. So if you get over that amount that you're authorized for, we ask that you return it to Social Security directly so that we can bring it back in, update our records, and then reissue the money directly to the claimant.
Sure.
If I can intervene, my suggestion, based on this happening to me several times, is since we're all getting paid directly electronically, put them out, get a trust account check, send it to Social Security, or bring it yourself if you can, and get a receipt. But if you're going to send it to Social Security, send it certified mail. Don't send an extra check, God forbid, to Social Security, because you may never see it again, and if it gets lost, then they'll come after you for more. So that's the way I've always handled it, if that helps at all.
Yep. And is ISSI online?
So the ISSI is the online SSI applications. It is available in certain cases. The agency is pushing more towards a web-based program for our SSI applications. We have a lot of that advanced. They actually just rolled out some more for us so that more of our process is through this web-based program instead of through the query system, the PCOM system that we use on a regular basis. We're trying to get more web-based to make it more user-friendly, to make it more up-to-date. So the ISSI is the online stuff that we get. So those are the online SSI applications that come through the door. A lot of claimants are able to file online, but like I said before, a lot of claimants are not, and we're working on trying to get rid of more of those exclusions.
Okay. All right. I think that's all the questions I've seen so far.
Josh, can I ask one right here? Just a minute. Kristine or Brice, you both talked about some cases can't be appealed online. My understanding is you can't appeal cessation, maybe not child's SSI, disabled adult child. Is that right? Are there others, or can you tell us that?
A lot of cases can be appealed online. Cessations cannot, as far as I'm aware, because there's so many other things that come in with it. It's a different appeal. So
Right.
with a cessation, you're appealing it with a request for hearing of disability cessation or request for reconsideration of disability cessation. Instead of just a regular request for reconsideration, we go through like benefit continuation during the appeal process. We have other forms that we need in order to do that. So that one is not capable at this time. We're hopeful that in the future it does come in, but we get a lot of disabled adult child claims appealed online. Those are extremely possible. We see them all the time. SSI disabled child cases can be appealed online. It honestly, I can't give you a rhyme or reason as to when it can be and when it can't be. Sometimes the system just is not letting us. So our recommendation is to try it. And if you are unsuccessful in trying it, then we ask that you send us the appeal paperwork in the mail.
Okay, thank you. Josh, we out of questions?
Yeah, we actually do have one more. It just came in here. How are PUA claims handled with an SSD claim?
So the PUA claims, we know a lot about PUA at this time. So unemployment was, released with the pandemic last year, and a lot of our claimants were getting SSI, and SSI can be affected by any income in the household. And so we always want to be made aware of that. PUA does not affect Social Security disability benefits. But we don't know how unemployment is affected by that. So our recommendation is always to have the claimants contact unemployment to make sure that they're aware that the claimant gets Social Security disability. When it comes to SSI, though, we do need to be notified right away if the claimant has been found eligible and is awarded those benefits, so that way we can update our records accordingly.
And then I think we have one question for Brice. This individual has multiple cases that are currently with 561 appeals of award letters after getting ALJ favorable decisions, but they frequently sit for 6+ months at SSA payment processing. Is there a way to put pressure on the payment processing department to address the recalculation request? We were previously provided with a list of phone numbers to contact based on the claimant's last 4 SSN, but not getting the issue resolved.
Yeah, I mean, on our end at DDS, we're looking at making the medical determination. So anything on that back end about payment issues and whatnot, those just have to be directed more to the field office or to the payment center directly, I would say.
Sure. And I would just add as an aside to that individual too. Sometimes that might be when you want to get the congressman or senator involved as well, the constituent services office. Sometimes I've had more success through that because they get an answer a lot quicker than I would get. So that might be one avenue for you.
Well, Josh, if that's it, then I think we can extend our thanks to Kristine and Brice for helping us today. We appreciate it very much. And ordinarily, if this was a game show, we'd have a home version of the Social Security section game for you guys to bring home and play with your families, but I haven't gotten that done yet. So thank you so much. And my guess is that given the break we already had, the leaders of what's now known as Carrie's Roundtable, aka Carrie, are probably ready to go unless anybody feels we need a break at this point. Otherwise, are we ready to roll here, or do we need a minute to break Brice and Kristine out and get whoever else is out in? Okay. Don't go far, guys, but we should be back online very, very shortly. All right, seminarians, we're back. And this part of the seminar is the brainchild of Carrie Spencer, so it's called Carrie's Roundtable. The thought was from the section that were people. Well, it's been a confusing time to practice in this area of law, to be fair, and it's sort of intended to be a chance for people to get some concerns out. Use the limited brain trust here. When I'm referring to myself, the other four I'm sure can help you, and to try and make sure we address some things, talk about issues. I kind of alluded to a few of them when we started. Anyway, contrary to what one would think, we're going to start Carrie's Roundtable with Greg Fry, because Greg's one of these guys who's working, I think, between at least 3 different OHOs, and he's got some input on the central scheduling issues that I'm sure some of you have been aware of. So without further ado, thank you, Greg. Tell us what you can.
Thank you, Jim. So I did a presentation a couple of years ago when CSU was just coming online, and I time to talk a little bit more about them now. I think most people have now integrated from the original system where you had 2 or 3 different emails you had to submit schedules to. So I think everybody's pretty much on one single email if you're in Michigan. Now, if you're practicing in other states, then certainly you're dealing with more than one CSU. But I think for most people that are probably on this call, you are looking at the Michigan CSU at this point, which does cover, I think, all of the lower peninsula OHOs, plus Toledo is there for some of us that are in lower southern Michigan. But it seems like it's all seamlessly fitting together for the region. And at least from that perspective is working. I do know there's still quite a few problems going on dealing with CSU. The hold of people at CSU is pretty difficult. There's really no direct phone lines to anyone regionally, and CSU is expecting that you will contact them through those emails. So when they send you that email to schedule your next month's send in your next month's schedule, that is also the same email they expect you to use if you're having problems and stuff. Everybody hopefully has ARS access now, where you can get on and you can see your schedule. If you don't, you should be doing that. I tend to check my schedule every Monday, and then often at least one other time during the week. That is updated every day. So you could, in theory, go online and check every day and see when your hearings are being scheduled. You have a very limited and narrow window when your hearing is scheduled to catch any mistakes and problems. They originally told us, I think a couple of years ago, it was going to be 3 or 4 days before the notice of hearings were actually issued. It feels like to me they're going out almost as soon as they're scheduled. So if there are problems, there's a very limited time to get them dealt with before your clients get their notice of hearing. And of course, from my perspective, and I assume most of your perspectives, that is the big issue. So a problem comes out, they've double booked you, they've put you on a day when you told them you weren't available. Suddenly client gets the notice of hearing, they're very excited, and then you've got to tell them that was an error. Me personally, I want CSU to deal with those errors if they make them. If I've sent them my schedule on time, I've told them what days I'm available and not available, then from my perspective, that's their problem for not following along. And I've noticed a lot more problems recently. I would say over the last 3 or 4 months, things from my end have gotten a lot more difficult. I had 8 hearings scheduled for May, and 4 of them were on the same day at the same time. So quite a mess, and took phone calls to 3 different OHOs to try to get everything resolved. But I was able to get it resolved. And I think that's the important thing to take out of this, is that you need to learn who your OHO reps are, and who you can talk to about these things. And that takes some nice phone calls and some understanding that the people you'll be finding and talking to aren't your enemy, and they aren't doing the schedule, but they can help you fix it. Unfortunately, I don't have permission from any of the people I talk to give out names, other than I know that LaShawn Rice, R-I-C-E, at the Detroit OHO is the or is a coordinator for the region, and if you call the Detroit OHO and ask for whoever deals with problems with CSU, that is who they will put you through to. She is very pleasant to deal with. And for the most part, if they recognize that they've made the error, they will help you fix it. Please keep in mind that just like everything, they have an order for how things need to be fixed. So of those hearings I had, 2 of them were aged cases. So those 2 had to stay where they were, and the other ones had to be moved around. So that's why it took a little bit of negotiating to try to move them around, but they will do it. And the old, you get more done with honey than the other thing. It really applies here, and the people I dealt with were very pleasant about it and took care of that. But it's not always that case. I had a case in Lansing that got scheduled when I wasn't available, and I was basically told, email CSU and tell them to fix it. And CSU told me by email that I should request an adjournment from the judge. And I, of course, told them absolutely not. I wanted nothing in writing that my client could use against me down the road to say, well, you had this hearing date and you should have changed your vacation plans, or you should have moved your other hearings, or whatever it was. And I told them a flat out no. And I got a call less than a day later from someone in Lansing who got it fixed for me, and everything was good, and client was happy, I was happy. So you sometimes have to be firm with them, especially with email, but they will fix things, especially if they recognize that it's their problem. The other thing I did is I put some fairly specific instructions on my email that I send every month as to my available dates. I was putting the available date first and then the instructions second. I've moved that around. The instructions are first now, and then they can find the dates. That may be more work for them to look for it, but at least they have to read what my restrictions are. For example, I'm only doing 1 hearing a day these days. I have enough cases that have been resolved with the push, and I think most of us are looking for cases right now to keep ourselves busy. I don't need more than 1. I'm over 50 now, and I don't want to stay up that much getting 2 or 3 cases ready the night before, or even 2 or 3 days before. So, if they're double booking me, I'm telling them, look, you knew not to double book me, so don't. But they will work with you, and I think that's where we are right now. You just have to keep on them, make your contacts with your local OHOs. The HODs will direct you to the right people if it gets to that point. And just be persistent with them, and don't let them, push you around. And every once in a while, you may just have to do a hearing when you don't want to do one, like a big hearing that you told them you won't do. Sometimes it's just easier to do those if it doesn't really mess up your schedule. So I think that's where we're at with CSU right now. I think it's moving forward okay, but make sure you keep on them. So back to you, Carrie.
Yeah, does anybody have any questions on scheduling?
Anything show up on chat on that one, Josh?
Yeah, there was a chat, and just a kind of chat entry that one individual had forgotten about the scheduling email from a few years ago, and asking if that was still a thing. It is. You should actually be getting an email every month from Region 5 CSU asking for your schedule. Right now, I believe they're asking for July,
June.
if I'm not mistaken.
Yeah.
July.
June? Okay. July. I think it was July. Yeah.
July just came out.
Yeah, those are due. Correct me if I'm wrong, Greg, but isn't it next week? We got to get those.
February 22nd. Yep, on Monday.
Yep. So if you're not getting those emails, I'm not sure how to rectify that. But you definitely should be getting those emails if you're listed as rep, and you should be responding to that email address with your availability to make sure that you're not getting cases scheduled and you don't want them.
So in regards to maybe some other issues that are current, I in the last couple of weeks, I've received actually 2 appeals council remands because they don't have the recording. So I think that's going to be happening more. It unfortunately probably has to do with remote recording and the logistics of the technology, especially in the months of April and May. So I thought that was interesting. The appeals council is actually looking at that. Another thing, a little nugget that I came across is that there was a directive given on February 5th. Apparently, Social Security is being very lenient in finding good cause for filing late because of the U.S. Postal Service and the atrocious service that's occurred in the month of December and January. Yeah, you might want to use that language. It's actually found, they gave a COVID-19 directive, and there's actually language in it that says, I did not file my appeal because Social Security offices were closed to the public due to COVID pandemic, and I'm now past the date for filing. And there's other language and whatnot. So apparently they're being very generous in granting good cause. Speaking
Carrie, on that
of,
note,
yeah,
I was just going to say, I've noticed that at all levels, good cause is going fairly well if you allege that it has something to do with COVID, the pandemic. I've had pretty good results with, I didn't even know I could hire an attorney right now.
Yep.
And at recon level and at OHO level, getting them pushed through. So even if it's several months late, go ahead and file it. It's better than starting.
Yeah, no, that's right. I mean, I'm not talking days. Even I did one that was 3
I'm talking
months.
months.
Yeah, months. I mean, and that would be laughable in the past, but it isn't now. And it is, just on that note, it is kind of sad because claimants are going to the office and seeing their closed and they think they can't file. I think there's going to be a plethora of cases coming down the pipeline once they reopen. I mean, it's astonishing that, I mean, we know claimants, I mean, they give up easy sometimes, and just not very, savvy as to what to do. And that's just so unfortunate. The only other thing that I thought was, I wanted to bring up was, elections have ramifications, and thankfully for us, they're good ones. What happened, and the reason that is because basically anything that's on the table as far as waiting for approval by Office of Management and Budget is withdrawn, so it's gone. So thankfully that included some of the issues regarding CDRs, the proposed regulations on age categories, and more importantly, the musculoskeletal listing changes that were quite drastic. So that's a good thing. Those are all being looked at as gone. That also brings up the topic of Saul and what's going to happen with him, and no one seems to know, but for that he mysteriously had the word acting placed by his name in January, and nobody knows why, and I'm sure there's a funny story somewhere in there, but Better Call Saul is maybe going to be no more. Yeah, it's he is definitely acting, and we're not quite sure. His appointment ends in 2025, but Biden hasn't fired him yet, or maybe I should use a nicer word. But there's no talk of who's going to be it and whatnot. So we'll see. Other than that,
I wanted to touch on one thing, Carrie.
Yeah.
Earlier there was a question about why can't the HIPMERs be done at the hearing office. I've had mixed results. I think it's kind of a case-by-case basis. I've sent letters requesting that a HIPMER be run for claimants. Kind of with my update of these are the providers that I've ordered updates from. I've noticed these are, these 5 treaters are Spectrum Health affiliates. I'd request that you run a HIPMER so all of the records get into the file, because they basically can download it within a few minutes. And then I follow up with a phone call if I don't see them in the file. And sometimes the assistant a legal assistant for a judge is like, oh yeah, no problem, and they do it right away. Sometimes they say, well, I got to check with the judge. Sometimes they want you to order the records first. So I think it's a maybe judge by judge basis, or just the assistant you get. Some of them are just happy to do it because it takes them 2 seconds, and other ones, they're busy and they might not want to help you out.
Nick, how do you like the HITMER when it comes across? I'm not a huge fan of the way it lumps an entire health system worth of records together, and especially if you've got someone who maybe has 5 or 6 different doctors. It's really hard to follow the flow of doctor to doctor when they're all just basically in date order. How do you work through that when you get those? Because I see quite a few of them with Henry Ford and Beaumont and Michigan Medicine and Art Heart.
Generally, from my experience, they've been, I mean, they're relatively well organized chronologically.
Right.
As far as, so, I mean, yeah, it's different doctor to different doctor, but I also feel a little more comfortable knowing that, because sometimes there's we've all had clients that forget about, they saw this doctor, they saw that doctor. Sometimes there's records that wind up in there that I really didn't know about because there was another, Spectrum Health affiliate that they didn't tell me about, that there can be something important there. So it's kind of I know they're not as pretty of records as some of the other, when you order it the other way, but I like the wide net being cast personally.
If I could follow up on what Kerry was talking about, obviously the elections had some very significant effects on what might happen to our clients. I mean, I think it's pretty clear the Trump administration is planning on eliminating the grid rules. So those I don't think are going anywhere. And
Yay.
Yeah, really. I mean, the man of the people did everything he could to destroy the Social Security system and the post office. Now, the post office may be a kind of a preview of what happens with Social Security, because obviously I don't know how long Mr. LaJoy is going to be continued there. I suspect not long. But I guess he went over the $2,000 limit. My understanding is for Medicaid limits of $2,000 for a single person, $3,000 for a married couple. And if you think about it, it discriminates against renters in favor of people who own homes, and all kinds of problems with it. But that limit is we're considering raising it to something like $10,000 with an inflationary riser. And obviously that might be very important for a lot of our clients, because the limits haven't been changed in 20 years and they're just ridiculous. So that may be something we want to be kind of vigilant about, because if that, I guess it can be changed administratively, and it's on the Biden administration's radar. So that might help a lot of our people. That brings up the issue of, it's funny that I guess one of the ALJs in Grand Rapids alerted me there's a case being in this U.S. Supreme Court about the so-called windfall provisions in Social Security, which of course always work against people who don't have much money. So there are some things brewing that could make things a lot better. Maybe one of the things we should be talking about is, how you'll win an SSI case, and then the person will end up with $500 a month because they're allegedly getting free food or help from a relative or something like that. And I don't know that I've been good at this, but this might be worth putting on our newsletter or whatever. Do we give a person who's in the situation where they're living with mom or dad or a relative or whatever a rental agreement saying, I've got to repay? Now, I've seen a lot of back and forth about that on listservs, but especially in light of the way these poor SSI people are being cut to death by the Social Security Administration, that might be something we need to focus on more. Just my thought on the matter.
No, you're right. That is a very hot topic right now. In fact, they've even given forms for rental agreements that you can enter in with your parent or your relative for the in-kind reduction that they're giving so quickly. It's a sticky issue, though, I think, because I mean, you want to be telling the truth. Are they really paying rent? I mean, I've always shied away a little bit from that, because you don't want to counsel your client that say you're paying rent when they really aren't. I mean, that's not exactly ethical.
Carrie, I've noticed lately too that they are actually looking for proof of payments.
Yes, they're being a little more militant.
20 some years of doing this, they're actually asking for that proof.
And you know, I don't
I've really
begrudge
changed
him
on that.
that. Is it legit or not? I mean, you don't want to be just saying it for the sake of saying it, and you certainly don't want to be counseling your client to be saying something that's not true. So, like I say, it's a sticky issue.
It's an issue.
In my
It's an
book.
issue we may need to explore
Yeah.
more thoroughly, either in the newsletter or at future seminars. But if they do change those limits on assets, which are God knows way overdue to be changed, that like I got one guy who keeps getting denied SSI because he has a 1970s Harley Davidson motorcycle with sentimental value that doesn't run. Literally.
Mm-hmm.
Josh, how are we doing on questions there?
We've got a few comments. So one of them, has anyone done a status check to find a decision was issued that was never sent out? Getting some of these lately, neither me nor my client received it, but SSA says it was issued months ago. Show of hands, I have.
Yes.
I'm getting some late.
I noted I think I noted on the listserv a couple of weeks ago that a lot of my applications that I'd filed for my clients in April, I received representation acknowledgement in August of 2020, only to find, and assuming everything's going fine, and then we call in November, December, January, what's the status of this? It's been an awful long time to make a decision, and find out that the client was denied in July. So neither I nor the client was advised of that. So I think, as we noted before, I think Greg touched on this. Submit a good cause letter for late filing. Note that you never got the notice. Note that your client never got the notice. Blame the Postal Service if you must. But I found that is the solution. It is being headed into reconsideration. You may have to be a little bit more firm with it sometimes, because I have gotten some pushback from DDS workers to say, well, you got to start over. And I've told them, I'm not starting this over. We're not going to start from day one again. That's ridiculous. You have everything you need. Just open it back up and let's do it the right way this time. So hopefully those are less now than they used to be. I think a lot of that had to do with, it was April, beginning of pandemic. A lot of SSA was kind of all over the place, and there wasn't a lot of guidance as to what people should be doing. And
to sort of follow up on this, I know Carrie mentioned the appeals council. I've had at least a couple of cases where we filed, electronically like we're supposed to. And I've had to call the appeals council, say, it's been months. Where the heck is this case? It's not showing up on my list. And both times they've instituted it. But I don't know what's going on at the appeals council, whether the problems we're seeing at the district offices are also part of the appeals council. I should mention, I actually had two cases that were federal remands, and I lost the second hearing. So I did the filing exceptions. I did it within the 30 days or 35, whichever it is. And obviously that's always an issue for some of us. But then they took over 2 years to decide them. And the problem is you can't access those. They're not part of your appeals council list. You can look at your case in the appeals council, and federal court remands with exceptions aren't listed. And you got to call someone or get someone who will talk to you at the appeals council. We all know that's problematic at times. So I just had another one, which I'm going to file on the 61st day, because according to Cliff Farrell, they've got 30 days. You've got 30 days to exceptions, and then the appeals council's got 30 days where it can assume jurisdiction. So file on the 61st day in federal court. You can bypass it completely. And if you have one of those, maybe you've had better experiences than I have, but two plus years and not being able to find a file and not knowing what's going on was an awful long time. So between them not filing appeals and losing appeals, it's something to be vigilant for in the appeals council.
Yeah. We had a comment here, Jeff Kirshner, regarding appeals council, several cases coming back essentially with instructions to the ALJ to just beat us better. Has anyone else noted this as well? I have.
Yes.
I as far as what you can do about it, I don't know. I re-argue the case. I think that the ALJ, especially if it's being remanded to the ALJ, well, I had a situation where I had an approval and the appeals council remanded the case back, essentially issuing instructions for a denial, but making the ALJ do it. I'm optimistic that ALJ will not look kindly upon the appeals council substituting their own credibility assessments for his own. But, I would just argue the case again. I don't know. What are you guys doing?
I definitely am seeing that. I definitely agree with you.
Yeah, I mean, it's nice because you kind of have a roadmap for the way the ALJ was thinking when they denied the case at the first hearing. So it gives you an opportunity to create a record, a better record, and address any concerns. Sometimes, because these are non-adversarial, you don't have the other side arguing against you for you to counter their points at the time of the trial or the hearing. So and it's a little frustrating because I think it's one thing that some of the federal court judges and magistrates don't quite understand, that sometimes you don't know the way the ALJ is thinking on this thing at the time of the hearing, or else you would address certain things. But I think it's kind of nice because you have a roadmap of how their thought process was, at least when they denied the first time.
Yep.
Excuse me.
I would agree. There's another question. If hearings move to video, does that mean claimant has to also have video capabilities in his or her remote location as well as the representative, or does this assume we'll be together with our claimant in the office?
It assumes you're together, correct?
Okay.
Yep. And that's why we're not doing it. I mean, with all due respect, I've been extremely careful during the pandemic. I don't want to get COVID. I've been, especially being so close to the vaccination, and we are not going to open our doors yet to have claimants come in and sit with us during a video. I've had some kind of snarky comments, especially in Toledo. Oh, you're not with the claimant? Like, no, I'm not. There's a pandemic going on, but yeah, it's a touchy situation. I don't know how people feel about doing the video, but like I say, I'm not. Our firm's not.
I'm not doing them either, and our doors are open. We are letting people come in, but we're at maybe 5% of what used to come in the door. We're doing almost everything by telephone, and frankly, I don't want to sit in the room with somebody for an hour for the same reasons. I mean, you think back to the days when we were at the OHOs and your client would come in and like, oh, I was throwing up this morning. Well, that's nice. Why are you here? It's not going to change. If they have that hearing date.
Or no, I have MRSA. That's a good one.
Oh, God.
Like, really?
Thank you for coming
out
back
in public. Yeah. Have you told the health department?
Yeah. Let's see. All right. So we've got another question about fee increases. Any rumblings about a possible fee increase? I'm assuming above the $6,000 cap. Had that question a lot, basically for the last decade, I think. I don't think anybody really knows. I don't know about you guys, though. I haven't seen a $6,000 fee very often like I used to.
Well, I think, the late John Lewis, and there have been several, but I think before he died, the late John Lewis had introduced another bill to increase the attorney fees and peg them to inflation, if we have any. And obviously, I think the Biden administration, there's some movement towards, fixing the asset limits. And I wouldn't be surprised if they'd consider it. Of course, they've got a lot going on right now, but certainly now I think if you have the ear of one of your Congress people, even if they happen to be Republicans, you might talk to them and say, it's a 10-year thing, and we need, you need to get paid if you want to make up for some of these cases where, I've had cases where I haven't won anything, and I'm sure some of you have too. Or I think once I got a check for $3.95, and yeah, that was a memorable day. And so, if you have any contacts with federal people or congressmen, from whatever party. I think the Democrats, frankly, probably be a little more interested, but at the same time, all these offices have at least one person devoted to doing nothing but fixing Social Security problems. Do you talk to that person? Maybe you call them and say, "Hey, Mr. or Ms. So-and-so, this is becoming a significant issue." I think, you compare it with talking about the asset limits and talk about, by the way, nobody thinks of poor attorneys, although, as you know, we all know it's a struggle. But that might be a way to introduce the topic to your Social Security contact with your congressman or senator. I mean, I'm sure Stabenow and Peters would be receptive, but maybe that's one way to do it, because it is a problem. I can't remember when it got increased to 6,000, but it's been a long time.
Mm-hmm. Yep. Along that lines, and since it's tax season, everybody's getting their 1099s. Any idea where an attorney can turn to receive an itemized breakdown of attorney's fees paid over the course of the year if there is a discrepancy between the tax form SSA sends out and an attorney's bookkeeping? I believe they used to send those, but I don't think they're sending those anymore, right?
No.
All I've received is probably what you have. Although sometimes I get two. I don't know. It's because some of it's federal court work and some of it's not. A lot of the times I on the Martin listserv, I've seen people basically say, I ignore them. It's kind of like, okay, last year I settled a fairly good auto case, so I get a 1099 from auto owners for the entire amount of the settlement, which obviously, unfortunately, I didn't get to keep all of it. The client got most of it, obviously. So I don't know if your accountant has dealt with this before. Is this an issue where you just say, like with my 1099s, I didn't get all the money because some of it went to the client? You say with Social Security, this is what my books show I received, as opposed to this, and Social Security is a notorious history of being inaccurate in that. Probably should talk to your CPA, but those are some of the ways I've seen it being discussed, because obviously if you do any personal injury work, you're getting these big 1099s for money to pass through your hands. And if you're getting 406B, you're typically refunding the client ZEJA when you get that. So if you're talk to your CPA and say, how do we deal with this? Do we need an explanatory note? Do we do this? But if you've done any personal injury work, this issue has sort of come up already in that sense.
Jim, do you want to talk about the Griffith EJA?
I can if you want.
You sort of you introduced it.
Well, it's okay. I'm drafted. Sorry, folks. I didn't do that talkative today.
I mean, I can, but you seemed like you were hot to talk about it.
Well, it sort of alludes to what I started with when I started the seminar. There's a new case. I'm sorry. I could probably find it. If you really want to know it, email me and I'll do my best to respond. Sixth Circuit just came down with something, and again, this is a product of probably somebody doing something they shouldn't have taken to Sixth Circuit, and which questions EJA applicability for lawyers like us. Now, most lawyers and most judges, except magistrates, with the exception of one in the Western District, and it's funny, we have in the Western District, we always have one magistrate who doesn't want to pay any EJA. One current one, not as bad as it used to be, but we had one who literally, I won one case in 5 years, and he rejected my EJA because it was procedural and not substantive in a case where I had 3 treating physicians saying the client was disabled. So,
Are you not allowed to say the name? Is it?
He's retired. He's retired.
Oh,
but
I thought it's not green.
Got some judges who are
I know what he's talking about.
Okay.
Yeah, oh yeah, we all know who I'm talking about.
Okay. All right.
So the point being that some judges are more receptive to the arguments of the OGC than others. Now, Cliff Farrell initial analysis is that it's not as bad as it seems, but we better be prepared to read the case if you're filing EJA request. Now, one of the things I've mentioned over the last couple of years that I've been chair is we're really overdue for EJA increase. I mean, literally back when magistrate whose name shall not be spoken was there, he had the ironclad theory that it was $125 an hour because that's what the statute said in 82, and we weren't going to change it. Judge Scalia phoned home. So eventually I got somebody to, one of the other judges to say, well, 175 was a decent, reasonable rate. That was a number of years ago, and all the other judges and magistrates fell in line, except until the magistrate, who will not be named, retired. But there were some times when I'd get a stip where I'd in effect force him to pay me my rate, which was a moment of psychic satisfaction for me. I think the 175 really hasn't been increased in a while, and it really should be. And the argument I'm seeing on the listserv is that if you think about it, the EJA saves the client money. I've gotten cases on the 406B where I've gotten up to in the neighborhood of $500 an hour. Now the offset, if you, let's say we were getting $200 an hour on EJA, which would be a reasonable, certainly a more than reasonable rate, then that's money the client eventually is going to get refunded if we're successful on remand. So I think it's something we probably need to address in maybe an article in a newsletter or at a seminar, because we don't know the fallout from the case that just came down in the last week or so from the Sixth Circuit. I think we're way overdue for an EJA increase because, frankly, it helps the client almost as much as us. But those are the issues I'm seeing right now. And in the Eastern District, people who do the Eastern District, are they paying 175 still as well, pretty uniformly, or is that? I seem to recall there's
185.
185.
You've been successful.
Oh, I'd love to see that because we're in the Western District, which is sort of notorious for, shall we say, not always being cutting edge when it comes to paying attorneys. But yeah, those are the issues. I mean, I think even on 185 is probably low, but we need to look at what happened with this case and then see if maybe my vision was that Josh and I and whoever else is filing in the state would start filing EJAs and say, look, we deserve a raise to 200, and it would be sort of a statewide thing and attack on all fronts. But again, I'm open to suggestions. But that's what I'm seeing right now. You in the Eastern District, you may have a judge or two who says, I hate the EJA and I don't grant it, or I rarely grant it. That seems to me to be the state of where we're at right now, which is a little confused. Am I making any sense? Did that answer the question, Jeff?
Yeah, it answers the question, but I think you're being optimistic, and I think you're right. We don't know the offshoot of it, and there are definitely attorneys that think that, if the poison seeps everywhere, because I think that's what somebody said, a reading of it means that you're basically going to be denied the EJA fee. So we'll see. But it is interesting and it is exciting that these cases are creating dialogue, provoking thought. It's also really kind of neat that these, cases are being certified for the Supreme Court. There's the Puerto Rican SSI benefits. Hopefully that'll be heard. And, there's actually Social Security cases making it.
Yeah.
Well, just the one
heard.
that Judge Ohanessian just mentioned, one that apparently may be getting cert. And, there are a couple of issues. Stop me. I don't want to take away from any of those questions. But there are some issues we need to sort of start setting up. I've done it a little bit like for our seminar. We hope our seminar in June. I've got Larry Rolfing coming again. Oddly enough, the guy from California thinks Michigan wines are great, so I'm doing my best to encourage tourism here. But if you look at his blog, it's in my article in the Bar Journal. Yeah, no, I'm not getting a concession on it, believe me.
So is that article out? Is that
it's out
yet?
It's on page 25 of the new State Bar Journal. They screwed up my joke about chicken sexers. God. That's another story. But Larry Rolfing's got a blog called California Social Security Attorney.blogspot.com. It's very good. He does a lot of work with vocational experts, but I believe his most recent one, I've seen notice of it, but I haven't read it yet, is that the treating physician rule is still here.
Sure.
Because let's face it, they didn't wipe out the regulations. They just trying to say, oh, well, part of what the Trump administration was ongoing doing, or with help from people inside Social Security, saying, okay, well, treating physician, we're not going to follow it anymore. But if you read the regulations, they have to. So I would recommend it, especially, if you're setting up a brief for the ALJ or whatever, or federal, you know, supposedly I think it was the March 27 of 2017. That was the end of the. You had to apply on or before that date, or the treating physician does apply. At least that's what they want to tell us. But I've been arguing it doesn't matter. It still does, because they didn't wipe out the regulations behind it, which may cue them to do that. But at least for now, they haven't done it. So yeah, I'm hoping Larry will still be able to come June. So far, I've got him committed to. But that's a really good blog to look at, especially if you're interested in that issue.
Very good.
So, Kerry, I've got a kind of a question here, Josh. PUA, it was brought up earlier and discussed in terms of how it impacts, especially SSI payments, but I'm more interested in how it's impacting hearings. I am starting to get judges that are asking my claimants in hearings, you know, I see you got unemployment. And, you know, as a practical tip, you have to make sure your clients are aware that they got those unemployment benefits because of the pandemic. And I had a hearing just this week on that very issue came up, and client was prepared for it. They knew to say that, you know, the only reason they got it was because of the pandemic. They did not have to certify they were ready and able to work, which is an important point in that. But I'm interested in how other people are dealing with that with their clients. And if there's anybody out there that does unemployment, I'm interested to know what the ramifications are going to be with unemployment, because certainly historically, you know, our clients are looking at a major penalty from unemployment if they get disability at the same time they're getting unemployment. So just curious what people's thoughts are, and certainly if you're listening to this, feel free to send in your comments on it, because I think it's something we're all going to be struggling with here as we move through it.
Oh, struggling is not even the word. I don't know. I mean, I really am very nervous that, I mean, and you know, it's funny, no one really wants to make a stand on it. I mean, if you, God rest him, I mean, Judge Burke, who was an unemployment judge, and he would just go ballistic anytime there was unemployment and accuse you of fraud because you can't hold yourself out to work and get disability, yada, 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 which technically he's right. And I suppose, you know, diehard unemployment people would say that. And we know that it's been litigated, and the reality of it is you needed the money, you were just collecting it. And the funny thing about it is a lot of those benefits you're not even certifying with Marvin. So you're technically not even holding yourself out to work if you didn't make that phone call and certify it. So, Greg, I tell clients I don't know. I don't know what to do. I don't think any of us. It's going to come back, you know, and some judges see, like when the big check came in last year in March or whenever it was, and then, you know, you see like $10,000 in unemployment. I mean, I've had judges go, wait a minute here, and you know, amend your onset date to after that. That's a little too much. I might not have a problem with some unemployment, but with so much, I can see their point, and that's you know.
I've been advising clients to I said you're gonna be okay as long as you're just open and honest with both agencies.
Right.
Obviously, you know what I mean? If there's some sort of issue down the road, if you've been upfront and honest about it, they're gonna be okay and probably have some sort of estoppel argument or waiver.
It was interesting, the Social Security, Kristine said that she didn't seem too bothered by it. I mean, obviously for SSI, but I was surprised to hear what she said and actually comforted by it. And it was kind of on that lines. It's not really, they're not making a big stink about it. But there are judges that will.
I was going to say I have a twofold problem with it. The client who hasn't told us about the unemployment, and we're suddenly getting ready for the hearing and we see it there, making sure they're advised, not having to certify, and that they were ready and able to work. And I think that's a major point with it, but it is coming up in hearings. I've had 4 or 5 hearings at least where judges have raised that as a potential issue. Mm-hmm. And if client's not prepared for that question, I think it can cause some problems.
I guess one thing years ago when one of our Grand Rapids seminars, I had to present on this issue, and there is that letter from an old chief ALJ saying basically unemployment shouldn't be an issue or concern here, and there's like the Cleveland Cliffs case and all that.
Yeah.
Obviously, well, the weird thing is I've done some unemployment in the past. I can't remember the last time I had a real hearing. It's like, I don't know if they're fighting these anymore, but they're still charging people with fraud, and you can't get anybody to respond. I've written, I've talked to state senators. I got this single mother of 4 who's got a $40,000 overpayment, because it was quadrupled because she alleged what I was seeing is people will go to their hearings and win or have these reps, they people hold themselves out as unemployment reps. So then the defendant would appeal, and the rep would never go any further than the hearing. And of course, given the unemployment agency's appeal board, the defendant would almost always win. There'd be no response. So then these people would get nailed for fraud. They wouldn't even realize it because, of course, they lost the case, so it must be fraud, right? And I haven't had a real unemployment case in some time. Like, you did this at work or I did this at work. And I've written, you try and find somebody. I think the sugar law firm down in Detroit had like a class action or something going on for all these people. But it's really confusing. At the same time, if we document that this is pandemic, I mean, you and I both know our clients are looking for any port in a storm, especially now. Most of them, a lot of them are probably in danger of being evicted, and they're not eating very well. And, the people we tend to represent that have taken the brunt of this pandemic. So, what do they do first? Well, there's unemployment. Sure, I'll apply for unemployment. They are unemployed. And a lot of them have this aversion to saying they're disabled. You get these people in your office, right? And say, well, I don't want to be disabled. It's like Judge Judy's on their shoulder or something like that. And they have this attitude, well, that maybe they can will through it. Well, you're not willing through most of the stuff we're fighting about. But of course, they're going to do the unemployment because it's faster, it's easier, and it's money, it's food on the table right now. But I suppose and I can try and dig up that letter because I know we put it out in a newsletter or something like that. But there's always was an ongoing issue about this even before the pandemic. But now, if your people are signed up for pandemic benefits, I think there's a much better argument to be made. Well, look, my client had a choice between eating or not eating. They'd like to work, but let's face it, they're delusional. I mean, wouldn't say that maybe out loud, but I think some of these judges appreciate that, and that's the attitude these people have. Well, I'm a hardworking American and all that. That's fine, but until you fractured both your legs with the spiral fractures, you're not going back to work, as an example. So that's one way you can deal with it.
But on the same token,
problem
because
is,
of the amount of money it is so much money. It is unreasonable.
And Jim, you're pointing out the fundamental problem here. Prior to March of 2020, if you had a claimant and you advised them to go with an onset date during a period they collected unemployment, I think you're pretty close to malpractice because the unemployment agency had the right to go after them for, I think it's quadruple penalty benefits on what they were paid. And I have seen them happen to people before.
Greg, remember Judge Burke? He would
post-pandemic, we just don't know what we're facing at this point.
He would tell you
that. That's the problem.
He would threaten to do it from the bench.
all true, Greg. It's just, I think the pandemic makes it more arguable. And,
I don't think being hungry has ever been an argument that has worked with a judge as to why you told one agency you could work and another one you couldn't. The point here is you've got to make sure that they are not certifying they can work, that the only reason they got the unemployment was to get the PUA benefits, and hope that the judge understands that that is the argument.
And not keep in mind work is the key.
And call your malpractice insurance carrier if you're doing unemployment law.
But on a
make sure they know.
On a happier note, I think that when the benefits run out, I think there's going to be a surge in claims.
Yes.
I think there are people that aren't filing.
Yeah, and keep in mind that if your client is above the age of 50 and getting unemployment insurance benefits, they can be ready, willing, and able to work a sedentary job, and that's not inconsistent with Social Security's rules. So Whether unemployment's going to understand that is one matter, but Social Security
Yeah.
should certainly understand that.
Well, certainly, I don't know if this is being litigated with the Michigan Supreme Court or not, but the idea that a plaintiff has to pay quadruple damages, but a defendant an employer wrongly denying benefits just pays benefits, seems to me one of the most ridiculous things I've ever heard in my life. But Josh, how are we doing on questions here?
Yeah, we got a few.
Okay, what are
So there's one back to taxes. So how to advise clients regarding when doing their taxes, because they're going to be getting 1099s from SSA that indicates the money paid out to them. And a lot of those, according to one poster here, will not take into account the workers' compensation offset. So even though they may have not gotten paid all of the Social Security benefits due to the offset, the 1099 is showing that they are. I don't know about you guys, but in any tax questions that involve my clients, I first off tell them the disclaimer: I'm not a tax attorney, I'm not a CPA. I advise them to take their award letter to a CPA or a tax attorney, and figure it out there. And then if they have any questions and that individual wants to contact me about some of the intricacies related to workers' comp offsets and things like that, they're more than welcome, and I can explain it to them. But I don't know the tax regulations and laws enough to advise my client on how to declare that or not declare that.
Well, exactly. It's kind of like our situation with the 1099s we get, and whether the CPA puts out a letter said this person really didn't get this money or this is why we're doing this. Yeah, don't make me your tax attorney. That's for sure.
The next issue is back to EJA fees. Is there a guide out there anyone would recommend for EJA fees? This individual has a case at the district court level that expects to be favorable. Yay, I hope it is. And would love to know that what EJA is and how to get it. So first of all, when we were talking about earlier about the rates and the hourly rate for EJA, keep in mind, everybody out there, that this board in particular, and thanks to Jim Rinck with specificity here, has tried to implore the State Bar of Michigan to list or at least get a survey of Social Security practitioners for the hourly rates that we would charge. As you know, we have the economics of law practice that comes out usually every year. But there's not a specific thing there for Social Security attorneys. There's one for administrative law attorneys, but getting that reference, so when you go to the court arguing that you are owed the $185 an hour fee, providing that overall reference of all attorneys in the state of Michigan that do Social Security practice would be a really invaluable asset for us. Social Security or the State Bar has not done that yet, but we be aware we are trying as a board to get them to add that specific part to their survey.
And because I think we're getting some more data, I think there are more and more surveys here. I think the 2020 one is out. I haven't looked at it yet about the economics of law in Michigan. Even just regular lawyers, our fees aren't certainly eclipsing, some of the higher specialties perhaps. But, in terms of a guide, I guess I would offer, if you wanted to, if somebody wanted to email me or you, we'd send them a sample EJA petition that they could work off of. That might be I don't know that there's a specific guide unless you read like the Bush book or the Boer book or, that kind of thing. Yeah. But those would be good resources.
A Westlaw search or Alexa search of EJA,
Yep.
You just search in your district, in the Western District, Equal Access to Justice Act. There's plenty of cases on there that kind of go through the process and kind of the elements you need to meet.
And it's a good time
for us.
Yeah,
Same thing with 406B.
Sorry. And it's a good time to note that I think we're going to have a discussion similar to this at our June seminar in Boyne, whether that's virtually or in person. I think we're going to spend some time on federal court work, specifically EJA fees. But as far as Jacob, I hope you do get that favorable decision from the district court. If you do, the thing I always recommend, first of all, and I've had a lot better success in getting EJA fees paid that way, would be to reach out to the attorney on the other side, special counsel for Social Security. Prepare your hours that you worked. You can only include the federal hours, the federal court hour work. You can't include the administrative work, but send that over to them. Usually if it's around 20 to 25 hours total in the federal court work, they will say that that's not excessive, and they'll kind of agree or stipulate to pay an EJA fee. I usually ask them for $185 an hour, ask them to stipulate, provide them my accounting of the hours. Usually they will stipulate to it 90% of the time. The 10% that they don't, it's probably not an issue with the hours that you worked. It's more have to do with the substantial justification. If Social Security was substantially justified in their initial denial, then technically you can't get EJA fees. But there's ways to argue around that, of course. That just kind of fact specific in your case. But yeah, if you need samples, reach out to listserv. Plenty of people that do federal court work, they can provide you a sample EJA petitions and motions, and help you out with that.
I'm sorry. I guess I'd say, if you're going to be serious about this business, I think the Tom Bush book is, I think, the gold standard in terms of a book that would guide you through all areas of this practice.
Yeah. Yeah. Let's see. Oh, also on the EJA fees too, you can also ask for your expenses. They come out of a different area, but it's good to get that filing fee back now that it's $400.
Well, you can also get the certain mail fees if you're doing service. I suppose you might even be able to make an argument if you had to use PACER fees if you could account for them. That's another one.
Yep.
If you don't get it waived already.
Yes.
If you get a fee waiver, I don't know if it's worth the trouble to get small costs.
I agree.
So, any other questions? There's a lot about unemployment, more kind of comments. Again, Judge Ovanesian notes that the unemployment insurance amount does show up in the new hire inquiry. So you can pull that up in the ERE. You should be able to see if your client has received any unemployment.
I would note.
Yeah.
I would note I have had. There's the couple, some of the federal supplement or for the gig workers and stuff. I have had claimants that told me they've been receiving that did not show up in the new hire.
Okay.
While we're on the new hire report, a refresher to some of our more experienced members, and if there's newer ones on here, don't forget to look at that before your hearing. You don't want to be blindsided in a hearing when a judge says, well, I see your client earned $5,000 in the third quarter of 2020, and you weren't prepared for that. So if you're not looking at those wage and unemployment reports, you should be. They definitely put information in there. And remember that the way those are reported doesn't necessarily reflect actual wages. You can get short-term disability if the company that your client is getting it from essentially cuts it from their own bank account. Long-term disability typically doesn't show up there, but vacation pay shows up there, sick pay shows up there. So make sure you're looking at those things, and it does show the unemployment on there, and you have to read them to see what's the difference between reported wages and reported unemployment. So do watch for those.
Yeah, and that's a good point. And obviously the first time that your client should be questioned about that shouldn't be by the ALJ at the hearing, because they do not know that shows up. They don't know what the ALJ is talking about. And if you have not prepared them for that, you're going to have a long hearing. But a note, as Greg noted, it's the first thing I look at when I pull up the file in the ERE, even before a hearing's been scheduled. It's the first thing I look at. It's also one of the last things I look at, of course, because they can get a new one usually the day before the hearing that you want to look at too. If something is showing up as wages in there, obviously talk to your client about it. Say, hey, what is this? You had $5,000 in the first quarter of 2020. You want to tell me what that's about? Because you're alleging an onset date of late 2019. And usually they'll say, it's vacation pay. It's I had short-term disability or something like that. Get the documentation, get the check stubs. That'll show what vacation pay is. It'll show whether or not it's an STD payment. You should get those and provide those into the file, and that'll kind of address that. So you're not just relying on your client's credibility to say that, it's vacation pay or sick pay.
And there's sometimes mistakes and falsities in there as well. I had a client who had worked always in Michigan, and there were some Miami, Florida earnings showing up. And apparently their Social Security number had been stolen, and it was being used at a restaurant in Miami. So you got to watch for those things too and be prepared for them so that your client knows that that's in their record and they can address it, that no working in.
And I've had
state.
that.
Yeah.
I've had that happen a couple times too, Greg. And obviously, you can ask your client about it when you're meeting with them, and they say, "Hey, I've never been in Ohio," or wherever the heck it is. And if you go through that on the record with the judge, I find they're pretty accepting of that. I mean, I think most judges are pretty accepting of the concept of this is disability pay or whatever pay it is. I mean, you give them a reasonable explanation. There may be a few who really want to see check stubs, but I think most of them understand how the systems work because, you know, they deal with them a lot. So, I mean, if you bring that out, I think most of the time it shouldn't be a problem.
Yeah.
Jim,
and,
the other one I've seen happen too is self-employment, where somebody used someone else's Social Security number for self-employment. I had a judge in Detroit that was ready to refer my client to the IRS, which I don't know if they really had that power to do that, but they wanted to, and they were threatening it. And this was not earnings my client had ever had, but it got reported as self-reported earnings by somebody else. And he was ready to crucify her for working and falsely reporting things to the IRS. So you got to watch those things.
And as a follow-up to that, so that'll address the issue at the hearing with the judge and Social Security. But there is a process to get those earnings removed, and those earnings probably will be removed through that process if an award of benefits is made after that determination, and they go and process it. The local office has a form for your client to fill out, similar to an affidavit, a fraud form that you'll see if you have a credit card charge you don't agree with, to remove that. But keep in mind that those earnings may have an effect on your client's monthly disability amount. And it takes a while to get those earnings removed. And what I have seen before, and what you should be advising your clients, is that there may be an overpayment, because once those earnings are removed, 6 months, a year, in my case, 2 years later, Social Security is going to come back and say, we overpaid you because we calculated your PIA. It wasn't accurate based on those earnings. And you owe us 10 grand. So you need to tell your clients that they need to remove those earnings, but that the monthly amounts they're going to be getting for Social Security are probably not accurate until they've received further notice. So it's hard to tell them what they should set aside, of course, but they should be prepared for an overpayment notice to come their way 9 times out of 10, because that's what will happen.
Of course, with our clients, the idea that they can set money aside is usually pretty limited.
Right. Yeah.
On the unemployment issue, I've also come across the situation where people get taken advantage of by the local tax guru, the person that offers to do their taxes, and they usually claim, around $10, $12, $15,000 for, and it's usually for like working as a hairdresser or something out of their house, and it just generates a very large, and when they're not actually working, and it generates a very large tax return, which the person takes off their hands as payment in exchange for doing their taxes for them. I've come across that a couple of times, and it's kind of a headache to deal with.
Yeah,
Josh, somebody just mentioned that can all affect your date last insured as well. So watch out.
That's correct as well. Yep.
Yeah. So, I mean, you get to, I don't know what these people do. They go door to door in certain neighborhoods and say, I'll do your taxes and get you a refund, even though you didn't make any money. I don't know how you could fall for it, since it's, of course, then you got a problem. You need to advise.
It's extremely pervasive in Detroit. I mean, it seems to come in waves.
Yeah.
And it's actually pretty common.
It's not so much maybe over here on the more pure east and west side of the state, but yeah, I've had people with it too.
The problem is, for me, is that their credibility is gone. They say they've done hair and they haven't done hair, and it's like, you can see the judge is struggling, and they should be struggling because it's not truthful, and it's just a very unfortunate situation.
Well, if you go back,
It's their credibility is out. Their credibility is out the window.
more than credibility, though. I mean, go back to my criminal law days. I mean, you're pretty much acknowledging a federal
Right.
felony. You tell them, look,
Exactly.
you're walking into this. You want to testify to a federal felony. You want to withdraw. You got a real problem there.
It's most unfortunate when that happens.
Jim, do you have a site for the Sixth Circuit EJ case?
It's Griffith.
Griffith,
The
thank
name
you.
of it.
Thank you, Gary. Well,
I'm glad you're so optimistic about it, Jim, because I'm not.
well, I mean, I having grown up as a West Michigan Calvinist, we tend not to be optimistic about much. But Cliff Farrell says that he doesn't think it's as bad. I mean, there's been a number of discussions about it on the Martin listserv, and Rolf Fang and some of these other big hitters have weighed in on it. And Cliff's, they're kind of thinking, well, maybe it's not quite the end. I mean, I can see one West Michigan magistrate right now is going to say, "See, nobody gets EJ," but almost nobody gets EJ with him anyway. So,
So that'll be really interesting to see what Cliff has to say at Boyne. That'll be great.
of course, then, and again, one of the arguments you make is, let's say you win the case, and you get no EJ, it gets remanded, and you get your money. And I've had cases where I got client over $200,000 in one case, and instead of getting them this discount, it's all coming out of them. And I mean, that's an argument that maybe we need to be making more. I haven't made it, mea culpa, but that if it's one of those more marginal cases, that's something that I think we have to point out to judges is that, look, in effect, if you take this money away from the client, from me, and if you think it's a worthwhile case, it's going back, but 2/3 of remands are result in victories, then that's money straight out of the client's pocket as opposed to saving them $4,000 or $5,000, $6,000.
Mm-hmm. Was that the Griffith case decided on February 3rd?
I believe so. Yeah.
Yes.
I haven't read it yet. I just saw it and thought, oh boy, I better talk to Cliff. So, and maybe Carrie, when's our next newsletter due?
March 15th.
Okay. Just a little incentive out there. Even quick hit, short paragraphs about cases you may have won or had interesting developments. We'll put them all in, and we'll try and develop something on this citation. Because Cliff hasn't gotten back to me with more yet about this, but we'll try and update things so people have an idea what this could mean for us. And of course, you're always welcome to email us directly if you have a question. Any more questions out there, Josh? How are we doing?
I think we've exhausted them.
Okay.
Josh, the Judge O just posted about unemployment, date last insured. I just want to make sure that everybody's clear. We are talking about fraudulent earnings on your wage history report. So someone took your identity, they worked under your social security number, it's showing up on your earnings. That can affect both your PIA, which is how much you're going to get paid, and your date last insured. Unemployment does not fit into that different discussion.
Correct.
Good point. Correct. Okay.
Thank you, Judge.
That last one trigger anybody's curiosity, or they all want to eat lunch now, Josh?
Nope.
What's for lunch, Jim?
Well, just to let you know, Greg. See, did I freeze? Can you hear me?
Yeah, we
can hear you.
You probably like it that way anyway. Then just to show you, Greg, yes, I wore a coat and tie. Yes, the Illini may get in first place by the time Michigan makes up all those games, so I figured I better celebrate. So, folks out there, we appreciate you participating in our, it's been at least 5 years, I think, since we had our February seminar. Please email. One thing, as I mentioned at the beginning, we're hovering on, do we do an in-person in Boyne, or are we going to do it all this way? I don't know. If people can email me or other members they may know and get an idea whether they think they'd rather get the vaccine and dodge a bullet, and maybe I'd have to open the bar up at Boyne again like the last time. But we're trying to bring you a good education, and the pandemic has not helped. But this I think has worked out reasonably well. Sorry about the glitch. Nothing you can do about it, I suppose. But please, articles, thoughts, emails, any input you have on what you'd like to do about the seminar, that would all be very welcome. Anybody have anything to add to that?
Nope. Hopefully we can see you all at Moyne.
Yes, we hope that's our hope. My wife's vaccinated.
Absolutely.
She's trying to get me vaccinated. So thanks so much, Annette. And again, I'm sorry, but we should have gotten a notice out sooner. The state bar lost my stuff. I don't know how, but anyway, we'll keep June in mind. That right now those are the dates, unless we have to move it. But right now that's the target date. Thanks. Annette did a wonderful job getting everybody registered and rebooted, so to speak. And thanks to all our speakers, including the folks from Social Security. I mean, I can't take much credit for this. This is your guys' brainchild, and you got most of the people. So thank you. Anything else before we leave?
Nope.
All right. Articles,
Nice meeting
please. We'll talk to you soon.
Okay.
Thanks, everybody.
Bye.